Hi, it's Nate Charles, and welcome to the Rule of Law Brief. Let me start by being very clear. I agree with almost nothing that the Trump administration did with respect to Venezuela. I'm not defending its foreign policy, its rhetoric, or its broader approach to the region. I am not advocating for what was done, and I'm certainly not trying to justify what was done as a matter of policy. What I'm going to do here is something narrower and more uncomfortable, explaining how U.S. criminal law has historically approached these situations, even when the underlying conduct is destabilizing, internationally unlawful, or deeply unwise. And that certainly applies to this situation. Those things are not the same. Here's a statement I have made and publicly stand by with important nuance. An arrest, like Maduro's, could proceed under U.S. criminal law, even though it would almost certainly be illegal under international law. That tension is real, and it matters. My interest in this is not just academic. It goes back to my time on active duty as a U.S. Navy SEAL. In practice, when the United States determines that an individual overseas poses a serious threat, terrorists, narco-traffickers, sanctions violators, hostile intelligence actors, it is often U.S. Special Operations Forces who are tasked with bringing that person into U.S. custody. That operational reality forces you to confront a hard truth early on. The legal rules that govern what happens in a U.S. courtroom are often disconnected from the international law rules that govern how the operation itself is judged by the rest of the world. The Frisbie doctrine developed precisely at that fault line. At its most basic level, the Frisbie doctrine stands for a narrow proposition. U.S. courts have traditionally refused to examine the manner in which a defendant was brought before them. If the court has subject matter jurisdiction over the offense and personal jurisdiction over the defendant, the prosecution proceeds even if the defendant was seized unlawfully. That principle traces back to Kerr v. Illinois in 1886, where the U.S. Supreme Court held that a defendant forcibly abducted from abroad could still be tried once he was before the court. Over time, courts summarized this idea bluntly: wrongly seized, properly detained. This doctrine did not develop in the abstract. It emerged from real violence and real jurisdictional breakdowns, and one of the most famous was the feud between the Hatfields and the McCoys. That feud, which straddled the Kentucky-West Virginia border in the late 1800s, eventually reached the Supreme Court in the case of Mahon v. Justice, decided in 1888, just 2 years after Kerr v. Illinois. A guy named Pliant Mahon was indicted for murder in Kentucky and fled to West Virginia. This was all part of the Hatfield and McCoy feud. While the governors of the two states were still corresponding about a lawful extradition request, Mahon was forcibly seized in West Virginia by armed men from Kentucky and dragged across the state line. West Virginia protested. Its governor formally demanded Mahon's return and sought habeas relief in federal court. The Supreme Court, nevertheless, denied habeas relief and held that the manner in which Mahon was brought into Kentucky did not bar his prosecution there as a matter of due process. The court acknowledged that the abduction was unlawful and indefensible, but it also concluded that there was no constitutional or statutory mechanism allowing a court to undo that violation once the defendant was being held under valid criminal process. Whatever remedy existed for the violation of West Virginia's sovereignty lay elsewhere, not in dismissing the criminal case. That decision reaffirmed the same principle announced in Kerr. Criminal jurisdiction is not defeated by forcible seizure, even when the seizure itself is unlawful. But it is important not to overstate how clean or how settled this doctrine really is. Historically, Frisbie arose in domestic contexts, like in the case of Pliant Mahon, and in cases involving private actors, not as a carefully reasoned rule for international or interstate abductions carried out in violation of sovereign authority. There is also a long and competing line of authority recognizing that treaty violations and international law breaches can, in appropriate circumstances, defeat criminal jurisdiction. There is also a basic interpretive principle in U.S. law, the Charming Betsy canon, which holds that statutes and doctrines should be construed to avoid violations of international law where possible. So, while Frisbie has been invoked for decades, whether it should continue to operate as a blanket rule, particularly in cases involving protested abductions, is very much an open and contested question. That said, whatever its theoretical weaknesses, the doctrine has been relied upon extensively in the post-9/11 national security context. Since 9/11, the United States has repeatedly taken the position, sometimes explicitly and frequently implicitly, that the legality of how a person is brought into U.S. custody is separate and distinct from the viability of a criminal prosecution once that person is here. Courts have generally avoided second-guessing national security seizures abroad, and prosecutions have proceeded without litigating the underlying operation in criminal court. That's not a moral judgment. It's an observation about institutional behavior. None of this makes such operations lawful under international law. Forcibly arresting a person, especially a sitting head of state, inside the sovereign territory of another country without consent is almost certainly a violation of sovereignty. Under international law, that can rise to a jus ad bellum violation, an unlawful use of force, and an act of war. And when the UN Security Council acts under Chapter 7 of the UN Charter, its resolutions are binding on member states. Absent Security Council authorization or host state consent, international law problems are obvious. But here's the uncomfortable truth. Those violations are not ordinarily remedied in U.S. criminal court. They are addressed, if at all, through diplomacy, sanctions, international claims, or retaliatory force. You can oppose the policy, condemn the escalation risk, and recognize the international law violations, which I do, while still acknowledging how U.S. criminal law has been applied in practice and will likely be applied in the case of Nicolás Maduro. That is not an endorsement of Trump's policies. It is a realistic interpretation of U.S. criminal law as it applies to national security prosecutions. If you want to criticize American power effectively, you should, but you have to understand how it actually functions, especially when the legal doctrines involved are strained, historically contingent, and increasingly difficult to defend. The Frisbie doctrine sits squarely in that category. Thanks for listening. We'll certainly have more about the developing situation in Venezuela as we learn more about what is going on.